Okay, good morning, everyone. My name is Barry Miller. I'm an attorney and the president of the Closing Agent. Thank you for joining our second real estate town hall meeting. Appreciate everyone that's tuning in. Please feel free to ask your questions. We'll try to get to all of them. And to recap, what we're trying to do today is to go through all the issues that are arising in the real estate field from a sales perspective on contracts and how to get to closing. And we're also going to be talking about the SBA program that affects realtors and how to apply for grants and for the PPP program. We're also going to go into the moratoriums that are on foreclosures and on issues involving evictions and modifications and things like that. So one of the things that's very, very challenging right now is in the real estate field. Realtors and title agents have been considered essential personnel, so we are up and running. All of our offices are up and running, but however, we've had to change the way we're doing business. We have to be careful. We have to take into account the safety of our staff, and therefore we've had to make some changes. So right now we're having only those people that are signing to come in. We're asking agents to appear telephonically or by video, FaceTime or other means like that. It's for your safety, for your client safety, and for the safety of our staff. But what we really would encourage people to do is to use either RON, which is remote online notarization, and it's not perfect. Some of the platforms out there are backed up, some of them can't verify, and there's certain challenges we'll go into in a little bit on that. But the other way that we really encourage people to do it is to use a power of attorney. So we will prepare a power of attorney free of charge and have one of these gentlemen that are here to be your power of attorney. We would go over all the documents with you on the phone prior, explain everything, and then sign it for you. That's the safest way to do it. It's the most economical way because it doesn't cost you anything, and it's just good practice to do that. And we'll get into that in a little bit. So today we're going to talk again about the POA, RON. We're going to get into that online. We're going to talk again about contracts and issues that have come up with force majeure and issues that are coming up on there, addendums and disclosures. We're going to talk about estate planning and again the evictions. So first I want to just introduce everyone, our staff of attorneys. We have 5 attorneys here at the Closing Agent Barry Miller Law to help facilitate closings and here for our realtor and buyer and seller clients. First we have David Berman.
Good morning.
Robert Garcia.
Good morning.
Casey Scalise. And Christian Walters.
Good morning.
So one of the things that we're going to talk about today is how to save the deals, how to keep going with them, and what I call it is a roadmap to resolution. We have lots and lots of challenges today, but we're going to show you how there's a solution. Let's keep these deals going, let's keep the market going, and let's keep the real estate sector intact. So first, Robert, let's talk about where we are with powers of attorney. I know that Freddie and Fannie have come out with some new guidelines and made some changes on there. So why don't you let everyone know where we are with powers of attorney?
Yeah, Barry, like what you said before, the powers of attorneys are a great way to have the buyers or the sellers not have to leave their homes to come in to close their transactions. Like you stated, the power of attorneys are free. Fannie and Freddie Mac have loosened their guidelines to make the powers of attorney more accessible and easier for closings to comply with lender and government regulations. What we do with our power of attorneys is we suggest that the individual, the principal, who's the person giving the power away, to identify 2 people, which are called the attorneys in fact, to sign on their behalf. The reason why we recommend 2 people is so that if one person is unavailable or sick, there is a backup person there. The power of attorney has to be signed before a notary, and it has to have 2 witnesses. So one great thing we can do with the closing agent is if your buyer or seller wants to use a power of attorney, we are able to do it and have it notarized online, I believe, through Ron. So they don't have to go out to their banks. They don't have to go out to someone they know who's a notary, because we can do it online remotely. So it can be a completely smooth transaction with absolutely no physical interactions for the agents and for the buyers or sellers.
So, and as a matter of fact, just this morning, I did a Ron signing with a U.S. citizen who was in Manila, and we had her sign the power of attorney, and so that way she can close in 2 weeks from now. We're getting everything else done very proactive. So what you're going to get from our office, once a file gets opened, you're going to get a flyer that we send out to the buyer, the seller, and the agents, showing the different options you have and how to make it a smooth transaction. We don't want to wait till 24 hours, 48 hours before closing and have the party say, oh, let's do a POA now. Let's take care of it right up front, because we like to get things done proactively and up front.
What's really important to just say again is it's a limited power of attorney. So for you guys out there to tell your clients, whether it's the buyer or the seller, it is limited. They are not giving us carte blanche authority to do anything on their behalf. It's specifically limited to the transaction at issue, which is the real property. So if your buyer or your seller has concerns about, can they go take a loan, or can they go buy a car or execute some other documents, absolutely not. It is strictly tailored to the transaction at issue.
Yeah, which is good to do, and it's safe to do. And the nice thing about it is one of our attorneys will be the power of attorney. So we got that extra layer in there. It's another set of eyes looking on everything just to make sure everything's good. A lot of people have said, well, I don't feel really comfortable giving a person at a title company or a realtor or someone else my POA, and it gives them that extra sense of comfort level on there to do that. So any jump in, every guys, with anything else on POAs, experiences you all seeing?
I actually did. I had one yesterday, and she loved it. The client was over in Deltona. She was purchasing a property. The documents were explained to her. It took about 45 minutes, and she enjoyed it. And she said she was not going to leave her house, and she was adamant in closing. So she said she had a great transaction. She loved it. It was smooth, fast, all the documents. We went page by page, and it was just almost like an in-person closing. No difference. Yeah,
and I'd really encourage everyone to do this. We haven't hit the peak yet. They're saying right now in Central Florida, we're not going to hit the peak till probably, there was a revision this morning. It was the May. Now they're saying April 21st. That's what the county mayor has said yesterday. So again, let's keep everything safe. Let's try to keep everyone at home. Limit activity outside. That's the way we're going to get past this.
Real quick, one other note, because you said to be proactive, one of the aspects of the power of attorney is it is a durable power of attorney, meaning in the event you should get ill, be in a hospital, and perhaps be incapacitated, then the power of attorney would still be effective and the closing could proceed. So your wishes would be met, because we would have the authority, and again, Barry suggested doing it early, at least a couple weeks in advance of the closing, so that everyone knows exactly the role they're playing, and that your closing can proceed smoothly.
Yeah, and that's a great point, because look, this thing's spreading and happening. We don't know what's going to happen, so that way get it done and have that peace of mind. Did you have something you want to add?
I was just going to point out the question that we received with respect to whether or not a foreign buyer can execute a power of attorney.
Okay, great segue, because that was the next thing I was going to go into. So let's talk about Ron. Ron is remote online notarization. We were the first ones in the state to do it. I was the first one to become a Ron notary, and we were experienced. We know how to get these done. As I said before, there's several platforms out there. None of them are perfect. But one of the things that the statute requires is KBA, and that's knowledge-based authentication. So what that is, a lot of you may have done that through your bank or other things, where the person is asked 5 questions. What street did you live on? What color was the first car? Things like that. So they've got to pass that in order to be authenticated so that we can notarize it online. So that's the challenge. So Kim, your question is, what if the seller, foreign buyer overseas? So if either one of them are overseas, here's the deal. they have to be they have to have a social security number, or they have to have a TIN number, and they have to have credit in the United States. So, for example, my person in Manila this morning was a U.S. citizen. They from Deerfield Beach. They're over there in Manila, but she had a driver's license, social security number, and she passed the questions. So that was okay. I had a gentleman a couple of weeks ago that is a Chinese citizen in China, but he had a TIN number and he had credit in the U.S., so we were able to authenticate him. So that's the challenge right now, to do it. So that's what we've got to do. So what do you do if you've got a person that's overseas? What we got to do is the old way is send them the power of attorney. They have to have it notarized overseas. I have a closing next week where the person was able to get it notarized overseas, and then they're overnighting all the documents to us, scanning them and then overnighting them. So there are challenges, but we're good about finding workarounds to get around those. So the RON is a great way to do it. Now, one of the other challenges is lenders will not allow buyers to close the complete packages on RON. It has to do with the note is a negotiable instrument. It has to be put into what they call an e-vault. A lot of lenders are not set up for that. So again, the alternative is just have the buyer give us their power of attorney. The lenders will accept a RON signed POA, and then we can go ahead and sign all the loan documents. So that's the way work around on it. All right, so now the other thing I want to get into now is force majeure and contract issues. We have been fielding hundreds of questions on this. Christian, why don't we just kind of give an overview of force majeure, and then we'll all share some of the stories and issues and questions that have come up and how to handle it.
So first and foremost, for those of you that have heard the term but have never really grappled with the concept, force majeure is a concept in contractual law which entitles one party to either suspend or terminate their performance under a contract due to the occurrence of an act of God. We can really kind of break that down into two separate areas. One at common law, which is judge-made precedent, case law, and things of that nature, and the other is force majeure provisions contained in a contract itself. We will be limiting today's conversation to the majority focused solely on the as-is contract. If you have questions concerning any other contract, the residential, for example, just note that the majority of our comments will be directed towards the as-is. So under common law, that's the judge-made rulings. In order for force majeure to apply to cancel or terminate a contractual obligation, that performance, your ability to actually do what you're supposed to do, has to be made impossible by the occurrence of an act of God. That's not going to help most people, the common law, because coronavirus isn't in and of itself making performances under the as-is impossible. So what we look to is the as-is contract itself, and it does contain a force majeure provision that allows you to suspend your obligations under the contract up to 7 days after the act of God, in this case coronavirus, no longer prevents performance, up to a maximum of 30 days past the closing date. And we'll start getting into a little bit of scenarios because as we're fielding these questions, we're finding that a lot of the time that provision is not really going to apply directly and really give people the best out. That being said, the primary and principal question that we've been receiving is after the expiration of a financing contingency, a buyer loses their job and is therefore turned down for the loan pretty much the day of closing when the lender is doing employment verification checks. And the loan's turned down. The question that we're mainly receiving is whether or not that buyer is entitled under the force majeure provision to cancel and terminate the contract and receive a return of their escrow. And I believe all of us here are under basically of the same opinion that unfortunately job loss and job loss alone does not entitle under the contract, provided the financing contingency is expired. It does not entitle the buyer to cancel the contract and receive a return of their escrow.
So the situation that keeps coming up is this: a house is under contract, the buyer gets their loan approval, notifies the seller they're approved, and then right before closing, the lenders are all re-verifying employment, they're doing some extra steps on there, and now the lender says, yeah, sorry, we know we approved your loan, but you're no longer working or change in circumstances, we are not giving the loan anymore. So a lot of people are interpreting that to mean is, oh, well, they're turned down, the buyer gets their money back. Unfortunately, that's not the way the contract is written. So again, what we're encouraging people to do is to maybe do an addendum. So let's talk about alternatives. How do you save the deal? What can a buyer and seller do? Maybe it's the job loss is temporary, and they know in maybe 60 days they're going to be back at work. What can the parties do? They don't want to get rid of the buyer, put the house back on the market. Who knows if someone's going to buy it?
Well, I think first and foremost, both buyer and seller need to be reasonable. I think approach the situation from a reasonable perspective. If you're a seller, you don't want to have to relist the property, particularly in a time when it's a challenge to show the property and to have buyers be able to see the property. If you're a buyer, obviously you're in a difficult position, but as Barry said, what is the circumstance exactly? Is it something that you may get rehired? We'll address the PPP, the Paycheck Protection Program, in a little bit, and one of the aspects of that is if you were let go, your employer may actually bring you back on because it could benefit them from the Paycheck Protection Program. So what are the specific circumstances? Be reasonable and communicate between the buyer and seller so that both parties are on the same page. If you're a buyer and you believe you're going to get your job back soon, let the seller know, and perhaps you all can arrive at an extension to the contract.
And I think another alternative option is having, it's a win situation for both the buyer and the seller is, what about a pre-occupancy agreement? That way the seller has the buyer moving in, which shows good faith and good intent to purchase the property. The seller's making money in rent most of the time. And the buyer probably already moved, had the intention to move, has his movers already lined up. His lease or her lease was probably expiring where he or she was living. So it's a smooth transaction and the deal moves forward. But again, a reasonable addendum extending the closing with a pre or post occupancy, well, in this situation, a pre-occupancy agreement beforehand. But it's really important that these agents be aware of that the pre-occupancy agreement should be carefully drafted, because you don't want to make sure who's going to be responsible for the maintenance, who's going to be responsible for the risk of loss if there's a fire in property. Things of that nature need to be addressed.
We got to make sure there's insurance. So don't forget the FAR bar addendum that says a pre or post occupancy agreement is not a pre-occupancy agreement. It's an agreement to make an agreement. So, and again, agents cannot draft these. I had something a few weeks ago that an agent said, oh, I found a form on the internet. We're going to use that. I filled it out. I drafted it. I changed it. Just technically, so you guys know, that is what they call the unlicensed practice of law, and it's a felony. Don't do it. Don't practice law. And because there's a lot of things that we can do. Because the other thing that's been coming up is the buyer has to be out of their apartment or whatever housing they're in and was planning on moving into the house. So again, the pre-occupancy agreement is a great way to do it. Now on the converse side too, sometimes we've had the situation where the buyer can close, but the seller for some reason can't move because of circumstances. So again, in that case, we could use a post-occupancy agreement, and that's a great solution on there. All right, so the other thing that's come up too, guys, is that we've had situations where another alternative would be is to do a lease purchase agreement. So let's discuss that. How can we use that as an alternative?
Sure. So when we talk about lease purchase agreements, I think it's helpful to first define what we mean. Generally, there are two types of agreements that result in a rent-to-own or a rent-to-purchase situation. Let me start right from the beginning and just put this out there. Please stop using a lease and the FAR bar contract together to try to create these on your own. The rationale being is that they're not linked together, and it creates some really interesting legal problems and keeps us employed but does nothing to benefit the client. So please stop using those. That being said, there are two types, as we discussed. There's a lease with an option to purchase, which is you make periodic lease payments, and at the end of the lease or a set time in the lease, you have the option to purchase. You're not obligated, you have the option. There's another known as the lease purchase, no option here, which is you lease the property, and at the end of the lease or a set time in the lease, you're obligated to then purchase it. You don't have the option, you're bound the second you sign the lease purchase. And you can use that in order to push out closing if financing is an issue, and to get the buyer into the house as soon as possible.
In these circumstances, in today's environment, we recommend the lease purchase. That way, what basically this document does is combine the lease provisions and the contract all in one document. And it's sad to say, as I did have an agent about 6 months ago that did a FAR bar and then used a lease. Don't forget, those leases are not FAR bar leases. The bar does not approve them. I don't like them. I will never use them, never recommend them. They used both of them. It created conflicts, and the parties are in a lawsuit right now. And the agent now has a claim on their errors and omissions policy because they went and did this. We will post, and just by the way, it's up on there. A lot of these things that we're talking about today, we're giving out these forms. It's on the closingagent.com/CVEDU. And if you want a lease purchase, there's a one sheet, very simple form you can fill out, and we'll post that on there. It's not on there right now, but we'll add it up there in a few hours. And you can fill that out, you send it in to us. You got to determine who's paying for it. You know, sometimes the parties split it, or it's whatever the parties want to do. But they're custom made, tailor made, so that we take into account all the circumstances and to make sure we use those. But they're a great alternative to use it. And part of the negotiation of those is for realtors is your commissions. So you have to determine, if you go that route, will you get a leasing fee? And then depending on how much is down, how much of your commission will it be paid at the end? I always recommend perhaps they pay half of it up front, and then the other half is due at the end. If it falls apart, maybe you can give your client a credit when you have to relist it. So there's all kinds of things, there's all kinds of suggestions that we can do for that. All right, let's talk about some other contract issues. What else calls have we been getting? Things that have been coming up. We've had some people, and let's kind of get into this, that are just saying, because of the situation with the virus, I'm not closing. I don't have to close, and I get my money back. We've been hearing that a lot. So let's kind of discuss, how do you handle that? And
so whether or not that is indeed the case is a very fact-specific inquiry, in that there are certain things under the force majeure provision that will enable you to use it and extend closing for that 7-day period after coronavirus ends, or 30 days past the closing date, as the case may be. There's no blanket, because there's corona, therefore I'm entitled to terminate the contract. That just simply doesn't exist. It's a very fact-specific inquiry, which determines, well, this is why I can't close, and then ask us, and we can help you determine whether that will in fact trigger the force majeure provision. As we said, most of the times it won't. I've also seen now sellers under listing agreements attempting to terminate them unilaterally simply because of coronavirus. This has come up 3 or 4 times in the past 2 weeks for me. Or simply sellers refusing to allow access to a property, to allow an agent to even go so far as to take pictures. And those situations, we'll talk a little bit more in our disclosures that we'll get into. What else are you guys?
You know, I agree with you, Christian, on the force majeure. For the most part, from what I've seen in the last 2.5, 3 weeks, it is not coming into play technically. I have a case right now where I've actually filed suit against the buyer, cash transaction, and the buyer is represented by a local attorney in town who also specializes in real estate, who's taken the position that his client is afraid of leaving the home, and therefore won't close on the contract, which closing date has now passed, and my client's instructed us to move forward with filing suit. It's a cash transaction. Insurance is not needed. Banking is not needed. The closing could have been done by mail away. Closing could have been done by mobile notary. Closing could have been done by remote online notarization. Closing could have been done through a limited power of attorney. But however, 10 times explaining this to the buyer and his attorney, they refuse to follow through. So force majeure, like you said, a carte blanche thinking of, I'm afraid, or I even have COVID, does not necessarily mean that you don't have to close on your contract, whether you're on the buyer or seller side. I mean, the language in the contract is narrowly tailored, and when you look at it, yes, this falls under an act of God, but the simple fact that the virus is out there is not preventing you from securing insurance or securing financing, because the governor, the president, the Department of Treasury have notified that businesses such as settlement services, notaries, real estate services are essential services to the national economy, and we are able to move forward. So buyers and sellers need to be careful when they're using this force majeure provision, because they may actually end up in a lawsuit. And what's really important for these clients to be aware of, the buyers or sellers, is there is an attorney fee provision in that contract, in the as-is contract. So if they breach, there are a lot of attorneys who will start taking these cases, if it's a strong one, and a $5,000 deposit can now end up in $20,000 or $30,000 if suit is filed.
Also, to follow up on what Christian said about it being fact specific, regardless of the force majeure, are you still within the inspection period? You could cancel under that. Are there any other aspects of the contract that perhaps the seller hasn't complied with? For instance, have they provided the HOA documents that may be necessary if you're in an HOA? Have they provided a prior title policy? So these are the reasons to contact us, because although you may believe, or your client may believe, they can cancel just because of COVID-19, there may be other contractual ways that we can assist in if they want to get out of the contract, possibly getting out of the contract, that have nothing to do with COVID-19.
Barry, this question is for you. Do you recommend that agents who represent buyers that work currently in the service industry, that are still employed but have a stark possibility of losing their job, do you think buyers agents should go ahead and extend the financing period for a set period of time?
If you think it's going to be an issue, absolutely. And one of the addendums, we have an addendum posted, a recommended addendum to use. Now, FAR has come out with an addendum, and with all due respect, I don't recommend using it, because it's a addendum that is to be used with the as-is, the regular contract, vacant land contract, and commercial contract. So it has things in there that don't apply to the as-is contract. So the one we used that we've developed is specific to the as-is contract, and it will address the problem on there. But yeah, again, use this as a method to a roadmap for resolution. If the buyer thinks it's going to be an issue, talk with the listing agent immediately. Tell them, be upfront, be candid with everyone, and let them know. Let's figure out how to get it done. Maybe a pre-occupancy, maybe the lease purchase, because if they're in the service industry, maybe they need 3 or 4 months. So let's do it that way instead. There's so many good alternatives out there to do. Absolutely, keep the communication open, and remember, be nice to each other. Be cooperative. This is a time of peril and things that are going on. Whether you're dealing with anyone in this industry, the lenders are on edge. Don't forget, besides all the purchases, they're also dealing with tons of refis right now. So, a lot of people are working remotely, and you've just got to be patient. Things are not as fast as they used to be, and we got to get things done. So let's also talk then, anything else as far as you guys seeing a lot coming up with the contract issues?
Well, I will say, some brokerages have now issued their own addendums regarding COVID-19. And it's important that these agents out there be aware. Read the addendum. If you don't understand it, contact us. One of us can explain what your broker or your company is issuing on the addendum. There's one addendum floating out there from a major real estate brokerage here in town, that if you're representing the seller and you're just following your company's guidelines and having everyone sign this addendum, you're doing a disservice to your seller and to yourself, because you will lose out on this commission. This specific addendum from a major brokerage in town states that if the buyer or seller, or the buyer or seller's family member or household, which that's gonna become a question of fact of what directly is an immediate family or household has COVID-19, then they have the right to cancel the contract.
So would that mean your second cousin twice removed on your father's side?
Maybe so. Well, here's the thing is, immediate family member under this contract. So, I'm buying a house, I'm the buyer, my cousin or my sister in New York now gets COVID-19. That under this contract permits me, because that's my immediate family member, to cancel the contract. If you're the seller and listing agent, you're gonna take the position of, why does your sister or your father in Arizona or New York or Milwaukee, the fact that they have COVID-19 allows you in Orlando, Florida to cancel your real estate contract? And it's absurd to me, but when you don't follow through and you're not reading the documents carefully, agents are losing out on deals.
Well, and the danger of this thing too is, in this major brokerage, I was told, they've instructed their agents to send this out to all pending contracts, buyer or seller, and saying that their brokerage is requiring this to be signed, right? A brokerage cannot require this to be signed. People need to review it. They need to ask their attorneys to review it. You should not be interpreting unless you're a licensed attorney, because you got to be careful. You can't interpret it, and you may interpret it wrong. So be very, very careful. It's bad practice. It's just dangerous.
To carry off on that, obviously you guys know, as Barry said, the Florida Realtors sent out their own COVID addendum. Obviously we don't recommend using that. Use ours. It's a little bit more user-friendly. That being said, I have received calls from listing agents where buyer's agents are calling them and saying, you have to sign this COVID-19 addendum. You have to, because of coronavirus. That's just simply not true. And that's come up quite frequently. That's not true. Use our addendum. If you're just extending a particular date, you can still use the simple extension addendum. Take a look at ours and use it if you deem fit, but there's nothing absolutely required to be signed. It just doesn't. It's not the case.
Because really, other than the financing period, stuff like the inspection or the pre-closing walkthrough, which I've encountered now 2 times in the last 2 weeks, is I have buyers saying, we can't close because I can't do the pre-closing walkthrough. Well, agents need to be aware that under pre-closing walkthrough, the as-is contract, it specifically states, first of all, it's permissive, it's not a mandatory requirement, but also it states that it's the buyer or the buyer's representative. So you can have your home inspector go back out, have the agent go back out. I mean, a lot of these agents are going out there doing virtual tours with their cell phones, do the pre-closing walkthrough that way. Let's keep the real estate community moving. Let's keep this deals going forward, because it's easy for us to do so. We just people need to act rational right now.
And in line with that, if you do an extension addendum, pick a certain date. I've seen a lot of addendums come through my office that basically say the closing is hereby extended until coronavirus ends. That's problematic. Who knows when it's going to end? Experts are saying it's going to become a seasonal flu, so it will probably never end. So always pick a certain date, and you can extend it if necessary.
Yeah, just choose your words very carefully, and remember, technically agents are not supposed to be drafting language that is on the additional terms. You've got to be very careful, because it becomes subject to misinterpretation and then arises to claims and litigation. All right, so let's talk some more. Now let's kind of go into some of the things we've posted and issues that have come up with addendums. So some of the questions have come up with, some sellers have said, well, wait a minute, how do I know if someone has COVID-19 coming in to see my house? I don't want them in my house, or I need to take reasonable steps. A buyer may say, how do I know the house I'm going into doesn't have some of the virus, because it can be on surfaces for several days. So, and then brokers and agents are saying, well, wait a minute, if someone gets exposed to COVID-19 as a result of seeing a house, could they come back after me? So again, we want to make sure you're protected. So let's kind of talk about that.
So we've prepared three separate addendums to a listing agreement and a disclosure. And I recommend that you guys go to theclosingagent.com, the CV EDU Center, which is posted here on the board behind us. And there are 3 disclosures that we've made. One for listing agents to get sellers to sign, one for buyers agents to get buyers to sign, and one for a listing agent to get prospective buyers that want to see a property to sign as well. And what those disclosures do, if you're the listing agent, they protect you against claims by the seller, or if you use the one for the buyer walkthrough, they protect you against claims by prospective buyers that they got coronavirus by viewing the property or something of that nature. It, in essence, states that you guys aren't licensed medical professionals. You're not going to be taking the temperature of everyone that walks in the home. And insofar as you guys represent sellers, the seller disclosure and consent also can change kind of the mechanics of what marketing efforts you're going to do. For example, you might encounter a seller that's not comfortable doing open houses because of the current COVID-19 situation. And if you use our disclosure, you guys can really limit the kind of marketing activities that you'll be providing as listing agents. And the seller can say, okay, you know, I'm comfortable with you doing online stuff. I'm comfortable with you photographing and doing 3D renderings, but I'm not comfortable with doing a full broker's open with 40 people in my home. So take a look at those disclosures, use them. If you have questions on them, by all means, give us a ring.
And I don't think anyone's doing open houses just open to the public. I know most brokers are prohibiting it and really should not be doing open houses that just anyone can walk in. It's just a dangerous precedent. So one of the other things that, as a matter of fact, came up yesterday is we had an agent that she emailed me and said that she had a listing from their seller, and their seller was also under contract to buy. And it was a cash transaction, and the buyer just said, I just don't feel comfortable going forward. I want to cancel. They had a $6,000 deposit. Can they just cancel? And the answer was no. It wasn't a valid reason to do so, and that in my opinion, that $6,000 deposit is in jeopardy, and it would go to the seller. And then pursuant, depending on what the listing agreement says, most listing agreement says that if the transaction doesn't go forward and the deposit gets forfeited, that the listing agent is entitled to 50%. And then don't forget, then the buyer's agent would be entitled to a portion of that also. So you've got that. So then the other issue was they said, and take my property off the market. I don't want to sell it anymore. So the question is, would the listing agent be able to make a claim now for their full commission? They were ready, willing, and able to list this property. Well, they did list it, and the listing agreement goes on. Under the standard FAR listing agreement, it says the broker may terminate the listing. They don't have to for a fee that is in blank. So if the listing agent says, no, I'm not going to let you out, are they entitled to then claim their full commission?
It's very possible that sometimes the agent can be able to claim their full commission, yeah. It has to be, fact-specific case, but...
I agree. An ultimate refusal to perform by a seller to perform under a listing agreement, or to even allow you guys to step in and do your job that you were under contract to do, would entitle you to the full commission. Also, carrying on with that, if you're already under contract and have located a buyer who's ready, willing, and able to close, and the seller just says no, I would also be of the opinion that that would entitle you to a full commission as well.
So let's take that a step further in that fact situation. So on the listing side, yes, they're entitled to a commission. Now let's go back to, they were ready to close next week, and that buyer, $6,000 deposit. Of course, the seller could sue for specific performance or agree to keep the $6,000 for their damages on there. Now the buyer's agent says, well, I'm entitled to my commission. Can the buyer then demand that they get their commission? The answer is no. The reason is because the buyer's agent does not have a contractual agreement with the seller. What has to happen is the listing agent can then seek relief in the courts to get the commission, And then once they got it, then they would have to then, under the MLS co-op, give that portion to the buyer's agent. Because we have had that happen before where the seller decides not to sell, and then the listing agent says, no, I'm not going after my client for the commission, and therefore they don't get it. And I had a buyer's agent that said, well, that's fine, but I will pay for the legal costs, I will do everything, you don't have to. And they just said, no, I'm not going to do it. And we determined we don't have a basis then to do it. So you've got to have the listing agent willing to do that, and that again is going to be a business decision. And to me, you know, the buyer's agent, it's really bad for them, because especially in the situation where it's the seller that walks away, and now they work so hard and don't get their commission. And this fact pattern before, it was the buyer's agent, it was the buyer that's walking away. So you've got to play on that also.
For those of you that use buyer brokerage agreements, a buyer's absolute breach of a contract or refusal to purchase a property also might entitle you to seek commission directly from the buyer themselves. So just be aware, if you're using those, be sure to look at those terms.
Yeah, I always tell my clients is, and I know we've been practicing this for years. Every agent out there, when they get their listing, they enter into that listing agreement. But when you're working with your buyers, get the buyer's brokerage agreement signed as well. Best practice to secure your commission, because you don't want the buyer and the seller to cut out the agents and try to negotiate a better deal. But what we were talking about right before was the listing agreement by far on the entitlement to commission. For those agents out there, and we just had this issue come up this week, who do commercial properties and are using the commercial listing agreement, be very careful. Please contact us. The commercial listing agreement specifically states that the seller has the right to cancel the contract and pay the listing agent a $500 flat fee. I think it's $500 on this specific transaction. If there's a quote, bona fide change in circumstances. Now, as lawyers, we all know bona fide change of circumstances means what? Question of fact for the judge. And that's going to vary from judge to judge, courthouse to courthouse. So in our one situation we've had this week, it was a multi-million-dollar deal going on. We found the listing agent found a ready, willing, and able buyer, and the seller refused to sell. And the seller has the right under this situation to simply cancel the listing agreement, and that listing agent was going to lose out on a big commission, because the contract specifically states that the seller has the right to cancel the contract for a bona fide situation.
Now that was to cancel the listing agreement.
The listing agreement.
But
the
in
buyer.
this case, though, they were already under contract with a buyer, so it's a little bit different situation. So again, we've said this, preached this for years. Buyers, have your buyer sign a buyer's rep agreement. But again, do not use the FAR agreement, because there's no attorney's fee provision in there. So if you get into a situation you have to go after your buyer and sue them, you want to recover your attorney's fees. We have one posted in our Realtor Resource Center on our website that has that agreement available to you. Let's go ahead and take a couple of questions in between on here. One of them is the seller required to provide the HOA documents? It's a little bit off topic on here, but in general, yes, the buyer, first of all, you have to go what the contract says. And I believe under the HOA addendum they do. So there's a couple of ways that they can provide them. One is most HOAs are online, and they have a link on there. So if you just send an email to the buyer or the buyer's agent saying, here are the HOA documents, or when you run a title report, they're there. The recorded declaration. Again, that's why we recommend you get that free title search that we do up front. Then you can have the HOA docs and then provide them right up front. Any other input on that?
Little off topic, but if you do have a property that's subject to an HOA, Jennifer, don't forget that you always have to give, so the way that the FAR bar addendum is actually drafted is it mimics what's required under Florida statutes to be provided. If you don't give that to a buyer before the buyer signs the contract, the buyer has a statutory right to terminate and walk away. So always be sure that you're appending that addendum filled out to the best of your ability to the contract.
So another question we have is if you're a listing agent is representing a seller and the seller contracts the virus, do I have to disclose it to the buyer? So that's a really good question because you guys have heard me say for years, disclose, disclose, disclose. You never get in trouble for disclosing, it's for not disclosing. So Casey, what do you think? Disclose?
I would say it's better to disclose because you don't want to get into trouble afterwards. You don't want to have to deal with this in the future. Just get it out of the way and deal with whatever comes next.
I would say it depends on the circumstance.
I would also err on the side that it's probably the better practice to disclose it. The law requires that you disclose material conditions affecting the property itself. So if the seller's living in it prior to closing and you have the buyer walking through, number one, that's just a liability. Just the risk of contraction is a little too high, and that if they're going to come after you for negligence. That being said, does it constitute a material condition that affects the value of the property? That's kind of up in the air. If the seller's living in the property and is coughing on everything, it may affect the value of the property for 20 days or so on after closing. But don't even go down that route. Go ahead and just disclose it. It's the better practice. Save yourself a headache.
So then the question is, how to disclose it? How do we disclose it? Call up the agent?
Always put it in writing. Definitely put it in writing.
Absolutely. You don't want to, when someone's calling you for showing instructions and then say, oh, and by the way, just to let you know, the seller has the virus. Be like, what? No. First of all, my feeling is this. If a seller has it and they're living in the property, it's probably a time to take a break. First of all, you should say to your seller, you need to take care of yourself. You should be in quarantine and you should not be showing your house. And if they say, oh, well, I'm going to go in the backyard, while they're showing the house. No, don't do that. Let's put people's health first. And let's do the common sense thing on here. Maybe instead suggest to the buyer to do some virtual tours, some virtual showings. And you as the listing agent, don't go in and do it. Maybe get your seller to be, get the people on the phone and go around and give a nice virtual tour with them. But let's put health first.
So I'm sorry for interrupting, but this goes back to the limited power of attorney though. If your seller discloses to you he or she has COVID-19, I highly recommend at that point that you recommend to your client to get the limited power of attorney. Because what happens if he or she now all of a sudden becomes hospitalized or has the fever and can't close, doesn't want to leave their house for closing. You want to take that precautionary step and be proactive because you want to earn your commission. You put the time, the work, and the expenses into listing that home. So that's one thing I would say.
So great segue now to if you know someone who has it or susceptible or someone who is older and has underlying health issues, let's talk about a little estate planning here, and that's one of the things we do. So David, let's talk, what are we recommending people do right now? Because there are some things to do, because if they do become hospitalized, or if there's different circumstances, you want to make sure that someone can carry out their wishes, carry out their business if they're in a business, or just their financial affairs. What's the best route to go?
So we've always provided will packages, and among that package includes a will, a durable power of attorney, and the two specific documents I'm going to reference, a living will and a healthcare designation. So obviously we're in a challenging time right now and medical issues are on the rise. The living will is a document that you are giving instructions to medical providers of any extreme circumstances or life-prolonging medical attention that you may or may not want. So if you should contract this virus and you get to the point where you become in a vegetative state or anything else happens, you are in a car accident and you have no likelihood of recovering, a living will is a direction to the medical providers that you don't want excessive medical attention to prolong your life. Now, this document has to be approved, or your diagnosis has to be approved by two medical professionals. It's not something that you stub your toe and all of a sudden the doctors can pull the plug. This is a very detailed document that explains the certain circumstances that you have to be suffering from, and it has to be approved by two medical professionals before it takes effect. Now, in conjunction with a living will is a designation of healthcare surrogate. This is otherwise known as a medical POA. This is where you are authorizing someone else to make medical decisions on your behalf in the event you are not capable of doing so. So again, if you contract the virus and you are in some kind of a state where you cannot be conscious or you are incapacitated in any other way, you have granted someone else the authority to make medical decisions on your behalf. Again, this document requires 2 medical professionals to declare that you are in a state that you cannot make these medical decisions on your behalf. Obviously, we highly recommend that this be a close family member or personal friend that you would appoint as your healthcare surrogate. Again, as Robert mentioned, have a successor healthcare surrogate as well. Have multiple people nominated as your attorney-in-fact under your healthcare designation, because obviously this virus is spreading quickly, and the person that you nominate potentially could become infected. So have at least an additional person nominated under your healthcare designation so that you have at least a couple people there that can make medical decisions for you in the event you're not capable of making them. Like I said, this comes included with our full will package. So if you are in a position where you want to be addressing your estate planning, take care of it all at once, and we can assist with that.
And part of that package is we recommend part of the package is a POA, a power of attorney, so that if you do need someone to take care of things for you, if you're hospitalized, if you're incapacitated, even though medically, you still be of sound mind, but you need someone to do something, this power of attorney gives them the power to do that.
So
and that's very important.
Right, and so the power of attorney we addressed earlier, where we can assist with a closing, is a limited power of attorney. The power of attorney that we include with the will package is a durable general power of attorney. It is much more extensive. It is granting power and authority to an attorney-in-fact to make financial decisions. It's allowing someone to do banking for someone else. It's allowing someone to manage their affairs in virtually any area of their life, excluding health, and that's where the medical power of attorney comes into play. But it is an excellent document because if you're in quarantine and you have business affairs that need to be taken care of, you have someone else available that can sign documents for you, that can go to the bank on your behalf, that can take care of these day-to-day routine events that simply you cannot do because you may not be able to physically leave your home. Again, the other reason we highly suggest utilizing a law firm for these documents, I've had a number of clients come in with either a will or a power of attorney, and they were not properly executed. Florida is a state that strictly interprets the statute on execution of these documents. So if you have a document that isn't properly executed, particularly a will, it won't be given effect by the courts, and what your family member thought their estate was going to be administered could be totally changed under the laws of intestacy, meaning the court doesn't recognize the will and your estate is going to pass, or their estate is going to pass in accordance with Florida law. It is very important that you have your documents properly executed, and that's one of the things that we assure is done on every one of our will packages, as well as our powers of attorney and our other documents we referenced today.
And the way we do it is to make it pretty simple, is someone just calls up, sets up an appointment, we do it by phone, get all the information to prepare the documents. We'll prepare them, email them to you so you can review them, get on the phone, discuss them. Then depending on, there's different alternatives for signing. You can come in to sign it. You have to have a notary and 3 witnesses. So we can do it that way. There are provisions under the new RON statute that went into effect in January that they can be signed by a RON. There's some challenges additionally on there, but it can be done. But folks, especially if you don't have a general power of attorney, we recommend you do that. And we charge a flat fee for it, and it's very reasonable to get. Any other comments on that?
I mean,
So-
I just highly recommend that everyone should now have their power of attorneys and the healthcare proxies and their wills, because
Yeah.
as we've seen, this virus right now touches everyone, from the Prime Minister of Great Britain to Tom Hanks, to world-class professional athletes. It's attacking anyone. So if you're married, and especially if you have kids, you're doing a disservice to your family and your friends if you don't have these documents in order.
Well, but even if you're a single person, if something happens to you and your family's out of state, Who's gonna take care of it for you? So you've got to look at that and be prepared for that. Unfortunately, we've got to be prepared for that. Okay, let's go on now to, let's take a couple questions. The question on here is, what if the seller tells us we can't? I presume you mean can't disclose that you have, that someone has COVID.
Right.
And the question goes on to say, we are not required to disclose if there's HIV, or if a murder occurred in the property. Is there a difference?
So Norma, I'll take this question because I've already answered it for you in the chat. The issue isn't framed so much as a duty to disclose. When we talk about corona, well, let's first separate the two. A duty to disclose material conditions that exist upon land is required of every real estate agent. So the question primarily is, does COVID-19 constitute a material condition existing upon land that would trigger the duty to disclose? That's kind of up in the air and is dependent upon the facts. But you can't forget that the question should more aptly be framed not in property or real estate law, but negligence, personal injury law. Nothing about the nature of our industry stops us from being bound by the normal provisions of negligence. A party's negligent when they have a duty to do something, they fail to do it, which causes harm to another person. Everybody has a duty to act as a reasonable person. So a court would say, if you fail to disclose it, that you're not acting reasonably to protect somebody else, which resulted in them getting coronavirus, and therefore you're subject to liability. If your seller tells you you can't, that's a little bit different, and I would typically recommend that you clear that relationship up very fast. The reason being is that can result, if you fail to do it, in liability against you as the agent, not to mention your seller can be sued.
Broker.
And your broker can be sued. So I want you to look at that not through the lens of real estate law or contract law. I want you to look at it through the lens of personal injury. And to get to your comparison with HIV and murder, first and foremost, the science is pretty clear. HIV is not, you can't contract HIV by the simple fact someone lived in a home and was HIV positive. That's just not possible. It requires some sort of sexual contact for that to happen. There's no such thing as getting HIV from a toilet seat. It just doesn't exist. The same with murder. Murder and HIV do not constitute material conditions upon land that affect its value. A social stigma in and of itself does not decline the value of a property, and it's not something society, as the Supreme Court said, to my knowledge, would be something that society would deem as materially affecting the value.
The one thing I will add in that situation is, if your seller has COVID-19 and refuses to allow you to disclose it to the buyer, I agree with you. You need to clear up that relationship with your client right away. But at a minimum, should you continue with that transaction and continue to represent the seller, and you decide to move forward, because like you said, Christian, the agent has a duty to disclose under Johnson v. Davis, I would at a minimum have the seller enter into an indemnification agreement for your agents, so that you are protected, so that if some attorney on TV decides to sue you, you can turn around and you can push the blame onto the seller and tell that seller, you hold me harmless. If the jury says I have to pay out $20,000, you pay it out. If I incur $20,000 in attorney's fees, you pay it out. So those indemnification languages have to be strictly construed. They can't just be drafted by an agent, because you are jeopardizing yourself in that situation.
The simple thing is don't let coronavirus be an abandonment of reason or morals. Just stick to your moral code. If something's
And use common sense, folks. Would you want to go into a home with someone that has the virus? No, you don't want to take that chance. So use some common sense. Okay, next question is, does HIPAA privacy rule apply to COVID-19 cases and disclosures? How can we possibly disclose either on the buyer or the seller side?
Okay, so great question. First and foremost, none of us are healthcare lawyers. That being said, take this with a grain of salt. I don't believe HIPAA applies to private individuals. It only applies to healthcare providers and people who report statistical information on health.
And I believe I saw something that in the emergency orders, there was some HIPAA provisions suspended or waived or something. I don't know what they are, but I don't think this would be covered. Obviously, if your seller or buyer told you they have the virus, it's not, they've disclosed it to you.
It's a voluntary issue, so
Right.
you're probably not running to HIPAA. First, I do agree with you from my limited understanding of HIPAA, is that it relates to medical providers and medical professionals. So A, that may take it outside the realm of the real estate. But in addition, if, like you said, Barry, if the buyer or seller discloses to you, tell the other side they've made a voluntary, commitment, and put it in writing, have the buyer or seller sign it, so there can be no, later on, the buyer or seller saying, why did you say it? Well, you told me to, it's in writing. You
Exactly.
acknowledged it.
If you're worried about that, go ahead and get it in writing that it's okay for you to disclose it.
Yeah. All right, the other question, what is the cost for the addendum that we were talking about to cover the agent from the seller and the buyer? Okay, what the cost is? Zero. It's for free. We just believe in these times, as a service to our realtors that we do business with, and quite frankly, for anybody, even if you're not. We just think it's the right thing to do. It's on our website, theclosingagent.com/CVEDU. The addendum's on there for free, and there's other documents that are on there. Okay, the next question is for pricing for POA, will, and the healthcare alternative packages. We do have that on, I'll let David go into that, the flat fee that's on there.
So, as far as the will package, for a single, it's $895, and for a couple, it's $995. And that is a simple will package. So if there's extensive estate planning, there could be additional fees, but for the most part, most people's estates will be the $895 or $995 for single or couple.
And that includes the will, the power of attorney, healthcare surrogate, living will, there's a few other things
Some
that are
ancillary
in there.
documents, yes.
Yeah. By the way, there's a lot of people who go online and find a will form and they think they fill it out, or they use these legal services. Probably 80% of the time they result in problems.
Well,
They fill them out wrong, they're not executed wrong, but even if they execute them correctly. I unfortunately had a woman about a year ago that her son had a drug problem, and she wanted to make sure that her sister, the aunt, had the money to control so the son doesn't take the $200,000 that was involved here and blow it on his habit. And she went online, did a will, executed it correctly, and unfortunately gave everything to the son. And unfortunately, the aunt did call me back about 6 months later and said it was all gone. And he's in jail because of his drug issue. Please don't use those online things. They're just, just like you say to people, oh, go sell your house on your own, you don't need a realtor. Yes, you do. It's a professional that watches out for you. Same thing with wills. Have an attorney that's a professional, prepare these, and get it right. It's peace of mind, folks.
And another reason why to use a Florida attorney for this is those internet providers and even your Office Max Staples. I had a client come in that did a will at that they purchased at Staples and they thought everything was good. Those are national providers, but the execution of these documents is governed under state law. And even though he had executed this properly in accordance with what was printed on the document, it was not valid under the requirements of Florida. So had he passed away and he thought he had done this will properly, it would not have been given effect by the court because it did not comply with Florida law.
Good. Okay, I think there's another question up above there. Do a quick review of the POA, safer way to close. Oh, sure. So in case any of you had joined us on there, one of the things we're really recommending right now is the best way to close is with a POA. Whether it's on the buyer's or the seller's side, we will prepare it for free for the limited POA for that specific transaction. One of these gentlemen will be the client's power of attorney, will review all the documents up front, then sign them for them. We can sign the POA via remote online notarization if the person signing can be authenticated. They have to be, have a social security number and credit, or a TIN number with credit, and then we can do it. This is the best way, folks, to do this, the safest way. Let's be smart about it. Let's start working smart on these for everybody's safety and trying to get that done. All right, now let's move into right now what's going on with evictions, because this is come up a lot. For those of you that are watching that are in Orange and Osceola County, which is the 9th Judicial Circuit, the sheriffs have said if there is a writ of possession issued, they will not be executing and serving them. So let's take this from two perspectives. First, let's talk about it because some of you manage property for landlords and or own property. What do you do? And then we'll talk about from the a tenant's perspective. So let's start out now. What do you do from a landlord's perspective? You have a tenant, they are not paying their rent. What's the options in the current state of affairs?
Okay, so I'll take this question, but I'm going to set the current state of affairs for you first. If you're in Orange or Osceola County, obviously, for those of you that have reviewed Governor DeSantis' order, it suspends, and who knows what suspends means, foreclosures and evictions for a set period of time. The Ninth Circuit's taken that a bit farther. Again, that's Orange and Osceola County, and they've essentially said, we're not going to allow the clerks to take any action on evictions or foreclosures at all, at least until May 19th. That being said, you can probably file a case, but you're never going to get a summons issued in order to get them actually out. We're running into this problem quite frequently. About 3 weeks ago, it was you could do everything up to the very end of the eviction, just you couldn't get a sheriff to come out and actually forcibly remove them from the property. Now you can't even get to that point. So if you do have a tenant still in a property, first and foremost, nothing stops rent from accruing. Rent is continually accruing. If you have a tenant who you'd like to keep in there but is unable to make the full amount of rent, we have an addendum that we can provide you for your lease that will suspend the total amount of rent or a portion of that total amount of rent for a certain period of time. And then after that period of time elapses, they can make up that amount that you've discounted in regular monthly payments for the remainder of the lease. That being said, property managers, stay on top of it. Obviously, rent continues to accrue. Try to work with your tenants if you can. If your tenant flat out refuses, get everything queued up and ready to go for an eviction. That way, the second that the court allows evictions and foreclosures to continue down the pipeline, we can get that ready and filed.
One thing I would say is just make sure, I know sometimes these property managers or landlords have a good relationship with their tenant, which is a positive thing. But if you are going to reduce the rent or you're going to defer the payment for X number of days or X number of months, it needs to be done in writing. Because 99% of all leases state that any changes to the lease must be done in writing. So you want to be careful and make sure it's drafted to accurately reflect. So there's several issues you need to address. First of all, how long are you going to defer the rent? Are you deferring the entire rent? Are you reducing the rent? What's the length of time? 1 month, 2 months, 3 months? What happens with that deferred rent? Is it going to be tagged on at the end? Is it going to be taken out of the security deposit? If it's going to be taken out of the security deposit, when is it going to be taken out? Today or at the end of the lease? We want to make sure you're in compliance with Chapter 83 Florida statutes. So there's various issues that they should think of and call us if they have any questions.
And again, it's got to be in writing, and the big thing is communication. Again, this roadmap for resolution is, and if you're a tenant, don't stonewall your landlord. Talk to them. We've seen some landlords that have said, I'm just going to forgive 1 month rent. I'm going to try to do that. I've had ones that will say, I'm going to tack it on at the end, or I'm going to break it up into 6 months payment to pay it out of 6 months after 3 months. There's virtually anything you can do, but everyone's got to communicate and everyone's got to agree on it. There's some people forgiving. There's some people that are waiving late fees. Now, on the other side, a tenant could file, a landlord could file the eviction right now. I don't think they're going to stop you from filing it. They're just not going to issue a summons. So if it is a tenant who's totally stonewalling, having a problem, I would recommend get it filed so it's all queued up and ready to go once that restriction comes off. There has been another issue on here too that's a little bit twist on this. So from the federal government, it says during the 120-day period starting March 27th, if a property owner has a mortgage on the property that is insured, guaranteed, supplemented, protected, or assisted in any way by HUD, Fannie Mae, Freddie Mac, the Rural Housing Voucher Program, then the owner cannot initiate actions for eviction or related to a tenant's non-payment for rent or fees. So in those cases, they can't even file them. Also on the foreclosure side, the order came out that said for at least 60 days beginning March 18th, a servicer of a federally backed mortgage loan may not initiate foreclosure, foreclosure-related evictions, or foreclosure sale. Also, we've been getting questions about people that are in their homes that can't pay their rent. They've also come out that says a residential borrower with a federally backed mortgage may request forbearance for a period up to 180 days and request an additional 180 days forbearance for a total of 360. Borrowers are eligible for this program regardless of their prior delinquency status. The key on that is they may request. There is no requirement that the lender must give the forbearance. So we have heard stories of lenders that say, yes, I'll take the request. They never hear from them again. They, again, put it in writing. Email the customer service email addresses for these lenders. Put everything in writing. Make sure you get everything in writing. So now on the tenant side too is I've got a report even this morning that there are institutional landlords who own apartment complexes. They have taken the corporate stance. If you're not payment in full, they have posted 3-day notices on everyone's door. I know in Baldwin Park yesterday, they did it on everyone who didn't pay, even if you owed a penny. So what does a tenant do? Well, first of all, contact the landlord and try to work something out, get it in writing. Now, could they go file the foreclosure? Yes. Is it going to go anywhere? No, not right now. We've had people that have said, oh, well, they can't charge me a late fee. That is false. They can charge you that. Now, let me throw something else out there to our panel. Most leases have a provision that if someone's in default, you can accelerate the rent and accelerate it to make the entire balance of the term. So let's say there's 6 months left. Can a landlord send them a letter saying, I'm accelerating the rent, you owe $10,000 now? Obviously they can't pay it. Can then the landlord file suit, not for eviction, but try to get a money judgment right now and then try to execute on the judgment?
You raise an interesting question. My answer is going to be probably not. The reason being is the law still does require reasonable mitigation, which means you have to prove that you're trying to find somebody who can afford the rent, and then you offset that total accelerated amount by the amount you're able to receive from the new tenant.
But if you can't mitigate because they're still in there, it's an interesting question. These are things that could be tested in there to do. The other question too is going to become, if we do a 2-count complaint, count 1 for eviction, obviously the court's not going to do it, count 2 for money damages, and the defendant does not respond, will the clerk default them?
I'm glad you asked that. No, they won't. If the case is filed and there's an eviction count in it whatsoever, they're not going to touch the case. This is going on with a commercial eviction I have currently, where the clerks refuse to issue a default on a 20-day, which is the monetary portion of an eviction lawsuit. They failed to do it for going on 2.5 weeks now. So based on my experience, they will not even entertain the proceeding forward of a claim solely for money.
Okay, so a question on here is, someone wrote in, Christopher, I'm under the assumption that we cannot serve legal notices for non-payment of rent at this time. only after the court system reopens. So if you're referring to a 3-day notice, yes, you can. You
So-
can post a 3-day notice.
The executive order says he's suspending basically everything under Chapter 83 for 45 days. Technically, I would read that as including 3-day notices, but so what? Even if you do it, I mean, there's nothing someone can come after you for if you post a 3-day notice. There's no legal cause of action to sue somebody for breach of an executive order. You can still do it, you just can't kick them out.
So could a tenant then later go that 3-day notice is defective because you didn't have the right to post it?
I would probably say no. The argument can go either way. Who knows? There's really kind of a novel issue of law. I would take the stance that it's not defective, but the 3-day is now extended to 45 days.
Right.
And I'm sure another attorney can take the inverse argument and argue that the entire thing is defective. Who knows what a court would say?
Yeah, and that's why, these large apartment complexes, we're getting reports, are just posting, wallpapering the doors in the complexes. Okay, then question, I was under the impression you can't use security deposit to cover rent. That is correct, and we're not saying to do that. What we're saying is, if the parties can come to an agreement, you do a written addendum that would allow that to happen. So for example, you have a landlord, we've had some landlords that say, look, I'm having a problem, I'm not gonna be able to pay my mortgage, and I don't want that to affect my credit and other issues on that. So one of the things we suggested is perhaps some of the security deposit can be released in writing in an agreement by the parties, and then that's the way to do it. So your answer is, can you do it unilaterally? No. Can you do it with a written addendum agreement? Absolutely. All right,
Let's
good
just care for
good
those agents
question.
to know there needs to be special language to clearly reflect, so that the landlord or the property managers don't find themselves in hot water for violation of Chapter 83 with regards to the security deposit. Like you said, it can absolutely be done, but it needs to be done properly.
Right, and property managers, no, you cannot draft that language. You can't.
We've had a couple already who found themselves in hot water. on those issues,
Yeah. So, okay, so now let's talk about the government, the CARES Act. So Casey's done a lot of research on this, so give us a little bit of background and what help is out there. The good news is there's $349 billion out there. The bad news is no one's received a penny of it. And as usual, the system wasn't set up for it. It is inundated. It is a total mess. But this is what, let's talk about first what the program is and things you can take advantage of, and then we're going to talk about the practicality of getting it in to get these funds.
Right, so as part of the CARES Act, the money set aside to help small businesses, the most helpful program is going to be the Paycheck Protection Program. So most of this information I've taken from the SBA and the Treasury. It has changed since the program was written into legislation, so just make sure that you clarify this with your CPA, with any financial counsel, and with your lender when you're doing these applications. So this condensed summary is going to be on our website right here. So check there for the extension of that.
Yeah, it's already up there. It's already posted on there. So first of all, let's talk about what is the most popular program and the one that we're recommending to our business clients and to our realtors to take advantage of.
Right, so the Paycheck Protection Program is likely going to be the most helpful for any brokers and agents, because 1099 individual independent contractors can also apply for this program. So this program is intended to keep employees on payroll. So for that reason, this is going to be a loan intended to be spent on payroll. This is a program giving forgivable loans up to 100% as long as you spend it on the right expenses. So the approved expenses that the Treasury has enumerated: payroll costs,
Speak up.
rent, mortgage interest, utilities, and interest on any debt obligations incurred before February 15th of 2020. So who is eligible for this loan? It's going to be small businesses under 500 employees, as well as sole proprietors, independent contractors, and self-employed individuals. That's likely going to be all of you. There are also certain other businesses that can apply, like restaurants, hotels, any business under the NAICS code 72, nonprofits, including religious organizations, and then some others. Those will also be on our website. So all you need to do is make a good faith certification that this crisis has affected you and that you require the loans for the purposes of alleviating this stress. To calculate the maximum loan amount that you can receive, it's going to be 2.5 times your average monthly payroll costs of the previous year, up to $10 million. So for brokers, what are payroll costs? It's going to be your salary, wages, compensations, or tips paid to employees, capped at $100,000 per employee on an annualized basis. So it's the first $100,000 of the past year. Included in payroll costs are employee benefit costs like vacation, parental, family, medical, or sick leave, allowance for separation or dismissal of employees, group health care costs and insurance premiums, and then the cost of retirement benefits. State and local taxes on compensation are also included in these payroll costs. For agents, so a sole proprietor or independent contractor, you're going to calculate your wages, commissions, income, or net earnings from self-employment, capped at $100,000 on the annual basis for each employee. So that's going to be yourself. It's going to be capped at $100,000 for the past year. Now, to obtain 100% forgiveness of this loan, you have to spend these funds properly, like we mentioned. So remember, this is to keep employees on payroll. The SBA has said that they imagine 75% of this loan must be spent on payroll costs to be fully forgivable. The other 25% is going to be spent on the rent, the mortgage interest on other debt and utilities, but make sure you're spending at least 75% on payroll to ensure that this is 100% forgivable.
One of the things that I recommend that anyone that is taking advantage of this and doing it, open up a new bank account. That way, when you get these funds, put them in that bank account, and then do all your expenditures that are within the guidelines here, have it come out of there. That way, if they audit you later, or you've got to submit documents to show that you spent it properly, you're not giving them your general account that's got all kinds of other things in there, and they're gonna go, wait a minute, what's that? What's that? That way, every dime that comes out of that account falls into one of these categories. It'll make it clean, it'll make it simple, there's no argument about it, there's no gray area, and that's just a good recommendation that you should to do with the funds going in and then going out.
Absolutely. And then another way that you can jeopardize this forgiveness is reducing your level of employees or payroll paid. So if you reduce the number of employees, your forgiveness will be reduced by the equivalent amount percentage in reduction. Also, if you reduce salaries or wages by more than 25% for any employee that made less than $100,000 in 2019, your forgiveness is reduced by an equal amount. Now, if you've already made changes between February 15th and upcoming April 26th, you have until June 30th to restore the employment and salary levels to the previous level so that you maintain that 100% forgiveness. So if you spend these loan funds on other business expenses that aren't in these approved categories, you're gonna have a loan that is not forgiven. It'll be due in 2 years, and it's a 1% interest rate. So all of these loan payments will be deferred for 6 months, but interest is going to continue to accrue.
So question, if for some reason they have to reduce and it's not forgiven, will the interest rate still be 1%?
It will be. It has changed a few times since it was released, but they have clarified that they feel a 2-year loan at 1% is an appropriate amount.
So if you're a small business under this program, you can apply now. If you fall under the independent contractor category, they're not opening that up until Friday the 10th.
Right.
So just remember, you can't do that.
Yeah, and the program is first come, first serve, so don't wait to apply. Get all the documentation you need, and then get that application in. The deadline is June 30th for these applications. There have been talks already at the highest levels of the government to increase the funding for this program, but we haven't seen anything yet.
So this morning, they interviewed our Senator Rubio, who actually chairs the Small Business Subcommittee in the Senate, and he said they are already working on to provide another round to put more money into this. So again, this is a great program to keep businesses viable and ongoing, which is important, but also just as important is to keep your people, if you have employees, on the payroll, and we keep unemployment down that way. For our realtors that are independent contractors, it's going to keep your cash flow going so you can keep your business going. And by the way, if you're brokers, you can use this to keep your office staff going. Now, when you calculate your numbers, brokers, you cannot use the amount you receive from your independent contractors in that figure. This is strictly for payroll. Now, some agents I know, they have paid payroll, and they have staff, assistants, and things like that. So you can take advantage of the payroll portion of that in there. Talk with your accountants and get your paperwork in.
So just to clarify, because I see the questions coming in, Casey, brokers can apply for the Paycheck Protection Program on behalf of their brokerage and their actual employees, and then agents have to apply on their own.
That is correct.
Okay.
You cannot include any wages paid to a 1099 independent contractor in your calculation of your payroll.
Well, they wouldn't be wages, just any
Correct.
amounts paid. So you've got your typical 80-20 split. Broker, you can't count that 20% that you get from your agent in there, and you cannot include your agents in your calculations at all. Agents, you have to do your own, but if you do have people under you, you may be able to include them if it is for payroll.
And then a challenge for some is going to be where to apply. So contact your current lender and see if they are still accepting applications, if they are lending under this program. Most SBA approved banks are using this program.
So this is a challenge right now, folks, because most banks out there are only right now handling these for customers they have. So first you got to check with your own bank. It's been reported in the media, Wells Fargo is capped out. They were allocated a certain amount. They're capped out. It's because some unusual circumstances with them. Most lenders don't have a cap, but most of them are, some other ones are saying they're no longer taking applications because they can't handle them. The other thing I would suggest to people is check with a credit union, especially agents. If you're going to go under this program, if you bank at a credit union and that credit union is an SBA lender, because that's one of the things right now. SBA lenders are the only ones that can facilitate these. If your lender, some community banks and credit unions are not SBA lenders, they cannot facilitate them. Under the bill, they are supposed to be able to sign up non-SBA lenders to participate. So far, they haven't done it. They haven't made it available. I know one of our clients that is a non-SBA community bank, they've been trying to apply and get it set up. They keep getting rejected, or now they're just hearing nothing. So that's it's an ongoing problem. So you got to go out there. On our website, we put a resource center, and on there is the list you can click on to see if your bank is an SBA lender. One of the questions that came in, what is the best program for a single agent? We believe it's under this PPP program. There are grants out there. We don't think it's the best way to do it, because if you do the grant and the PPP program, the amount you get from the grant will be deducted from the forgiven amount. So what we're hearing from everyone now is the PPP program. The other question, what about if I already applied? Do I have to apply again on Friday? If you applied as you need to check with your lender. Now, they may have taken your application and applied, but they may have not submitted it to the SBA. They probably didn't. And if they did, you need to talk with them and remind them that the independent contractor program is not until Friday, so they may have to resubmit. That's a great question. All right, another question is, as independent contractors with salaried, not real estate related income from last year count towards on the loan amount? Yes. So if you do some realtors set themselves up in their business, they either under a PA or an Inc. or an LLC. If they have them set up that they're under payroll, they can apply now under the payroll program. If you're strictly 1099, you have to wait till Friday. So yes, good question on that.
Just to clarify, because I have had two agents this week contact me already, just the CARES Act and the Paycheck Protection Program. They're one of the same, just to understand. The CARES Act, which is the acronym for the Coronavirus Aid, Relief, and Economic Securities, is the $2 trillion you've heard on the news. Within that program, within that piece of legislation, there's a subcategory called the Paycheck Protection Program, which is the $350 billion that we're discussing today. So for all intents and purposes, they're one of the same. So I know some agents are thinking it's a separate program.
Yes, and also under there is the EIDL grant.
Correct.
Also, if anyone does currently have an SBA loan, there's some other benefits under that we're not going to go into now because most people don't have SBA loans, but if you do, be aware under the CARES Act, you can defer and stop payments on that. But again, check with your lender, check with all of those programs. Another question, I heard we can apply for unemployment benefits. I presume when you say we, that'd be an agent who is a 1099, is 1099. Anyone have any information on that?
Don't have any specific information, but from what I've read online and been understood so far is that the agent cannot apply for the unemployment. And that's why they sort of passed this Paycheck Protection Program to include the independent contractors, because they're not employees of a business to collect it. But
So one thing everyone's got to realize is that unemployment, in Florida we don't call it unemployment, it's reemployment. And as we've heard on the news, the system's been crashing, it's had problems, it's supposedly been up. So unemployment, or in this state, reemployment, is state by state basis. Some states have extended it for independent contractors. To be honest with you, I'm not sure whether Florida has or has not. I believe they have not. But that is something that we can check into, and we'll post that in our site on there. Does anyone in our office do the grants for a fee? No, we're not doing that on there. My suggestion is talk with your, you really shouldn't have to pay someone a fee. You should, if you go with your lender, they should help you do that and apply for that through the program. Question is strictly based on 2019 tax returns because the tax deadline has been extended. Great question. So the answer,
So the
answer that one?
The answer is no. It's not based on any tax information from 2019. You calculate this solely on your past payroll information for the prior year. And so when you apply for this loan, all you'll need is the application form, which will be linked from our website, and any information that you need to prove your payroll expenses, or for independent contractors, any other salary information.
Right, so what they've said in here though, if you're doing it as an independent contractor and you don't have payroll, and great question, you have not filed your 2019 taxes, the statute says then you can use your 2018 1099. But you know, most people have gotten their 1099 for 2019, but if you have not, you can. They have said you can use your 2018. So that's a good question on there. So folks, there is help out there. There's going to be more on the way. So take advantage of these. And again, on the resource page that we've put up on there, we talk about the SBA program. Oh, we put the application on there. It's changed a few times. It's already on version 3. Also, there is the Florida disaster loans. I put that link up on there too. The EIDL program is up there. There was a great article that we put on the New York Times yesterday. I put that link. It's one of the best I've seen that really explains this in a great way. The U.S. Chamber of Commerce has come up with a guide and a checklist That's on there. There's an information sheet that's up on there too. So take a look at all those documents. You should be able to walk your way through. The key and right now is to find a lender, because the lenders they're just not set up for this. And it's gonna be interesting to see when this money will start flowing, because these businesses really need it. Okay, is there any other questions up there?
No, now.
I will just say one thing with
Okay.
regards to the Paycheck Protection Program, as Chris and I do litigation a lot, is I have my feeling is that the government, once the situation does resolve itself in the next year or so, the government probably will be auditing a lot of people's files and loans, because since the loan is being forgiven, some people may try to become greedy. So what I recommend to these agents is, A, don't be greedy, and B, make sure you have the documentation saved and supported, because if you are audited, they will probably pass legislation that it's a criminal offense as well as a civil offense. So you don't want to find yourself in hot water.
Yeah, listen, guys, do the right thing here. It's bad times, but do it the right way. And again, put that separate bank account so you have everything up there. Another question just came in. When applying for PPP, can I use quarter 2 through 4 of 19 and quarter 1 on the preceding year?
Based on an annualized basis, not on a particular fiscal quarter.
Right, so you may be able to do it that way, but again, check with your lender, because you're gonna have to give them the documentation. They package it up, they send it into the SBA for the approval. The funds, don't forget, these funds come from the lender. Your loan will be not with the SBA, your loan will be with your bank or your credit union. And you're gonna have to make your payments to them, and then they're gonna administer it. So again, work with your bank, and folks, the other thing too is, you gotta realize these bankers are under tremendous stress right now. A lot of these bankers have been working remotely for the safety of their employees. So you gotta be very patient with them, and they're at beyond capacity. They could probably double their staffs and still not be able to handle it. So it's on a first come, first served basis. So I know that's a little bit scary, but the good thing is there's already talk, there is gonna be more money. How much, we don't know. I personally think they're gonna double the amount. I think they're gonna put about another 350 billion in there to do. And I think there's gonna be other programs coming out too. I think there's gonna be other relief as this thing goes through. So, be patient. Again, just be really kind to each other on what's going on. So one of the things is, we're very grateful for all of you in the industry that's been keeping this industry moving. We're here for you. All these attorneys are here for you. I know some other title companies are either shutting down or they're not able to service them, and they're coming up with some other alternatives. Our first thing is the health of our staff and our people. We want to make sure they're not exposed, for your health and for your clients' health. I know that there's been some people that have been doing drop closings, where they take an envelope, drop it at someone's door, and then sign it and come back and hold their ID up to a window and they take the picture. We won't be doing that. That violates Florida statute. A notary has to see them signing it. There's other ones that are doing their so-called drive-through closings. To me, that's exposing people. You're gonna have to be at a car window. If that person's affected, that means that the notary is gonna have exposure. We've got great systems in place. You come in, if you have, again, we want you to do the power of attorney. Everyone can stay at home. If someone has to come in, the people that come in, you sanitize with, as soon as you come in, you're given a pen, taking it home. All of our rooms are wiped down, and don't be afraid. All of our staff will be wearing masks and wearing gloves. The protection of our people are paramount. And I know some people are offended by it, or they're insistent on other things, but people's health and safety comes first. We want to make sure everyone can get closed, and we're going to look at alternatives. Remember, it's the roadmap for resolution. We're here to help you and to try to get it through. Anyone else has questions you want to post on the site, we'll get to them and we'll answer them today. But the big thing, folks, is keep safe. Let's keep our industry moving. and, and be well out there, and if there's anything we can do, please let us know. So everyone stay healthy, be safe, stay in. If you go out, please take the CDC recommendation, wear a mask or a homemade mask. There's lots of places on the line that show you how you can make them. And again, as we've been for almost 30 years, we've been here for you. We're gonna still be here for you. And good luck out there and be safe. Thanks, guys.